Welcome to the JDG. We are very happy to have Laura Valentini from the LSE, and we'll discuss her paper, Claim Rights, Moral Theory, and Social Empowerment. So,
okay, thank you very much. Thank you, Presenter, for inviting me. This is my first time at the Jurisprudence discussion group, so I'm really looking forward to this, and thank you for being here. So the title of my paper and my talk, as you can tell, I guess, from the PowerPoint just behind me, is Claim Rights, Moral Theory, and Social Empowerment. I'm just going to start off by very briefly summarizing the main claim of the paper and then elaborate on the main sections of the paper as I go along. So there seems to me to be the following fairly common assumption in moral philosophy, and this is the idea that the function of the notion of claim rights, which is often equated to the notion of directed duties, which is often equated to the notion of duties owed to another. I'm using these as synonyms, and they often are in the literature. Some people disaggregate them, but here I'll treat them as synonyms. That the function of this notion is to designate a distinctive and important deontic status that accrues to individuals who are claim right holders. And in the paper, I'm going to challenge this idea, and I'm going to suggest that there's no satisfactory notion of a moral claim right that can actually perform this particular function. And so I'm going to conclude that either we should avoid the notion in moral theorizing specifically. So the thesis is confined to a particular domain of claim rights discourse, not across the board. So it doesn't apply to legal theorizing, doesn't apply to political theorizing or political advocacy, and I can say a little bit more about that later on. Or at the very least, seriously rethink the purpose, because if that's the purpose that it's supposed to play in moral theorizing, I don't think that the notion can actually, the function it is supposed to play, I don't think the notion can perform it. Okay, of course I can't read your mind, so I don't know how ex ante plausible my claim is going to be to you, but to at least illustrate how the notion of claim rights might often be associated with different normative attributes, let me give you a very simple, quite philosophically familiar scenario. So assume that Amanda is accidentally drowning and Bob could easily rescue her. Typical Singerian style scenario, but let's assume Amanda is an adult, because otherwise this doesn't work. And the question here is, does Amanda have a moral claim right to being rescued by Bob? And interestingly, whenever a question like this, I think, is put to an audience, everyone says, yeah, of course Bob has a duty to rescue Amanda. Where disagreement seems to get going is on the issue of whether Amanda has a claim right, and here I mean a moral claim right. It's going to be moral throughout the talk, to be rescued. And I think part of the issue is that the question itself is quite ambiguous, and in fact I think people might mean a variety of different things by it, some of which I am going to list here on the slide, but the disambiguations that I list are only sort of, I think, a particularly salient set, but they're non-exhaustive. So, is Amanda's interest in being rescued weighty enough to place a moral duty of rescue on Bob? One thing that we might mean by this question. Another thing is, does Amanda have the power to waive Bob's duty and or to demand its performance? Other thing we might mean. If Bob failed to rescue Amanda, but for some reason Amanda managed to save herself, would she have the power to forgive him? Other thing we might mean by this. Or would Amanda be morally permitted to threaten coercion to get Bob to save her? Or, from a moral point of view, should Bob be liable to state punishment if he refused to help Amanda? And or should Amanda be able legally to exact compensation from Bob if Bob failed to rescue her? Other possibility. Is Bob justifiably, but already as a matter of legal fact, liable to punishment in case of a failure to rescue Amanda? And is she justifiably, but already as a matter of legal fact, entitled to legal compensation from Bob if he refuses to rescue her? So these seem to me different things that people might have in mind when they ask the question of whether Amanda has a claim right to rescue against Bob. And so this at least should give some plausibility to the claim that at least the notion of a claim right tends to pick out a variety of different attributes. And not only that, at least as far as I am concerned, when I think about the answers I would give to these various questions, they tend to diverge. So I'm not going to answer yes to all of them or no to all of them. And you can see that if different people talking about claim rights have at the back of their minds different questions, it's quite easy for them to end up talking at cross purposes, looking like they're disagreeing, but in fact they're talking about different things. Okay, so I think this is the state of play, but of course this is just an illustration. The illustration that there is some ambiguity and potentially confusion doesn't show that the task of trying to define claim rights satisfactorily for the purposes of moral theorizing, that is such that they pick out a distinctive deontic attribute, is somehow hopeless. And I'm going to try to substantiate this somewhat more controversial conclusion as follows in the paper. So, first of all, I'm going to set out two desiderata on a well-functioning definition of claim rights for the purposes of moral theorizing, which I take to quite already implicit in many discussions of moral claim rights in the literature. Then I'm going to zoom in on the two most prominent accounts of claim rights, will and interest theories, and suggest that they fail to meet these desiderata. And this is going to be necessary background, even if perhaps 1% tedious, because everyone talks about will and interest theories and some of their pitfalls are quite well known, to putting forward my own more positive view that is suggesting that perhaps the most useful conceptual connection between claim rights and something else is the idea of social empowerment, and that so social empowerment in a way demarcates the conceptual terrain of claim rights talk, but at the same time I will try to show that conceptual terrain is too heterogeneous for a plausible notion of claim rights to actually pick out a specific deontic attribute, and then I'll draw some conclusion, namely ask whether we should avoid the notion for certain purposes in moral theorizing, use it a lot less than moral philosophers have done so far. Okay, so desiderata on claim rights to begin with. So just to clarify what I mean by a claim right, probably you can already guess this, but just to make sure we're all on the same page, I take a claim right relation to be a binary relation. Sometimes in the literature it's called a bipolar relation. I don't like that term very much because it seems suggestive of a psychiatric illness, but anyway, let's call it a binary relation between, on the one hand, someone who has a duty bearer, and on the other hand, someone who has a right or a claim right, I guess, and to whom the duty is directed or the duty is owed. And I take it, we want to know when we're asking how to define a claim right, what the claim side in this pair exactly amounts to. So what interesting deontic attributes accrue to a claim right holder? You know, we know that the duty is there. We know that there's got to be a duty. What is on top of that? What is the sort of special normative status that amounts to a claim? What is one of the two poles of the relations? What does it consist of? So, and it seems to me plausible to say that a good account of claim rights for the purposes of moral philosophy should meet the following two desiderata, or at any rate, it seems to me that this is what has been going on in a lot of the discussions. So one fairly standard desideratum is consistency with paradigmatic claim right statements. So the definition should fit most paradigmatic statements about claim rights. I don't think this desideratum is not overridable under any circumstances, but to the extent that our definition departs more and more from paradigmatic statements about claim rights, we have reason to wonder whether it really captures what seems intuitively interesting and important about this notion. At some point you get to the point where you ask, well, why do you use that label in the first place? Then choose a different label for the concept that you're trying to demarcate. And then the second one is deontic distinctiveness. So the definition, so the desideratum goes, vindicates the view that to be a right holder or the addressee of a directed duty is to possess a distinctive deontic status. So it has to perform that particular function. This is more sort of functional desideratum. So these are the desiderata, and I'm going to suggest that the will and the interest theory fail to satisfy either one or both of them, and then go on to explain what I think are the more structural reasons why not just those two theories, but any theory that tries to satisfy those two desiderata is probably bound to fail. Okay, so the will theory defines rights roughly as follows. So A has a moral claim right against B if and only if B has a duty, if and only if B has a duty, and A has the moral power to control B's duty, where controlling can be spelled out in terms of either the moral power to demand the performance of that duty or to waive that duty, to remove that duty. So fairly standard characterization. So we can now think about whether the will theory satisfies the desiderata of special deontic status as consistency with core right statements. And I think as far as special deontic status is concerned, the will theory does quite well. And the reason is fairly simple, that it does define rights by reference to a particular deontic status precisely that accrues to the right holder, that is, a power to control someone else's duty. So in that respect, the will theory is quite clear in telling us what's special about being a right holder. You have a power in relation to other people's duties that others don't have, and that's what, that's why you should be quite happy to be a right holder, because you have this very special status. I mean, I'm sure that will theories don't put it quite this way, but that's my gloss on it. They should be really happy. Okay, so in that respect, the will theory gets a tick. There's more to be said, but because I don't have a ton of time, and I'll just leave it at that, then we can discuss this in Q&A. What about consistency with core right statements? And I think here is where the will theory is known not to fare quite as well. In particular, if we take the will theory, it looks like we end up with both an undergeneration of right statements and an overgeneration of right statements compared to what we tend to think in more or less ordinary language. So undergeneration of rights, fairly well-known problem with the will theory, because the will theory sees rights as being connected to the power to control someone else's duty, and one can only have this power if one has a capacity for autonomy or a capacity for choice, then children, people with severe mental disabilities, non-human animals are ex ante, as a matter of principle, excluded from the realm of potential right holders, and that seems to be problematic because these are some of the creatures that you might want to say they have rights in the claim right sense of having rights. Equally, inalienable rights seem to be conceptually impossible on the will theory, precisely because if having the power to waive someone's duty is part of what it is to have a right, inalienable rights by definition can't exist. But interestingly, I think the will theory also seems to overgenerate rights. And that's because what the will theorist identifies as core to being a right holder is something that seems typical also of being a practical authority. That is, the power to place someone under an obligation or to remove that obligation, for example. So in the paper, I use the case of a policeman. A policeman says stop on the assumption that they have justified practical authority. The policeman telling me stop places me under an obligation to stop. But if I were not to act on that obligation, I think it would be a little bit odd to say that I violated the claim rights of the policeman. I've certainly disobeyed the policeman, but I think some of us at least might be a little bit, find it a little bit odd to say that I violated the rights of the policeman in the way in which, say, if not that I would ever do this, but if I were to stab poor Crescenta, I would violate a claim right of his. Seems that violations of practical authority are not the same as violations of claim rights, but on the will theory, the two seem to get a little bit too close to each other. So the problem of overgeneration as well. So does well on one dimension, but not so well on the other dimension. Let's move on to the interest theory. And the interest theory, I'm here using Joseph Razer's characterization of it. There are various cousins in the literature, but I'll just stick to this one. Defines rights as follows. An agent A has a moral right, moral claim right. Again, whenever I say rights, I always mean claim rights and moral claim rights in particular, against B, if and only if A's interest is weighty enough to place a duty on the other party. And again, relative to this definition, we can then look at our two desiderata and see how the interest theory fares in relation to them. So special deontic status first. And here, I think the interest theory gets a red cross. And the reason, I think, is well expressed in a passage by Simmons, who puts it as follows, and I'm just using his words because I think he puts it very well. So rather than being regarded as the correlative of duties, as a sort of deontic attribute that stays on the other side of this binary relation that I illustrated on the slides earlier on, for the interest theorist, rights should be regarded as marking the interest which justify the imposition of duties. And an interest is not really a deontic attribute. It doesn't have to do with duties, permissions, or things of that sort which are sort of connected to the deontic. So it's a justification for a duty. It's not a counterpart deontic attribute to a duty. And if that's what's special about rights, what we're trying to figure out is what it is, what the claim on the other side of the binary relation is, it seems that the interest theory is not giving us that. It's giving us something interesting, but not that particular thing. And I also think that as far as consistency with core rights statements goes, the interest theory is not fully satisfactory. There are some often raised objections to the interest theory in this regard, especially to do with third-party beneficiaries, but what I'm actually going to be focusing on here is another type of inconsistency, which is overgeneration. In cases of duties where we may think those duties exist by virtue of the fact that someone's interests are weighty enough to place a duty on a particular individual, and yet we wouldn't want to say that those duties are correlative to claim rights. And here I'm thinking about duties of beneficence, duties that you have to act for the sake of the good of someone else, and whose existence is explained by the importance of the good of someone else, and which yet don't seem to be correlative to claim rights. In fact, beneficence is often considered a moral category that is opposed to the idea of rights. I have the example of helping an old lady cross the street in the paper. But the worry there is that on the interest theory, we wouldn't really be able to separate duties of beneficence on the one hand from properly rights correlative duties. Okay, so just to give you graphic illustration of what I think I've said up to this point. So the will theory understands claim rights by specifying claim in terms of the power to control someone's duty. The interest theory, on the other hand, kind of forgets about the claim bit and just focuses on the justification for the duty side of the claim right binary relationship. And that justification is individual interest based. And I think that there are actually some systematic reasons why we end up being pulled in these two different directions when we talk about claim rights and think about claim rights. And that's what I'm going to try to illustrate in the next section of the talk and the paper, which draws the conceptual connection between rights language on the one hand, claim rights in particular, as I said, that's what I have in mind, and social empowerment. So that's what I move on to next. So it seems to me that if we think about broadly ordinary language discussion of claim rights, and I have to say that having worked in moral, legal, political philosophy for a while, sometimes I think that my intuitions about ordinary language may not be particularly reliable because, you know, I end up being surrounded with people who use terminology in a rather technical way. But, you know, trying to abstract away from that, if I think about how the notions tend to be used, my pre-theoretical, if I can still access them, intuitions about claim rights seem to suggest to me that this notion is connected to the idea of social empowerment in two ways. And I distinguish, therefore, between two types of statements, what I call justification moral rights statements and status moral rights statements. And I think that these are connected to the idea of social empowerment in the way that I'm just going to illustrate. And I'm first going to give you sort of the structure of these connections and then give you some examples. So justification moral rights statement point to the justification for conferring social empowerment on individuals. And so they take the following form. They take the form of the following kind. So the interests of a certain entity, those interests of that particular entity, merit a special kind of protection or empowerment within a given context. So from a justification perspective, a statement such as children have rights should be understood as follows. So there are certain duties to safeguard children's interests. But in this particular context, those interests are important enough that mechanisms of empowerment should be put in place to see to it that those duties are actually discharged. Now, what empowerment mechanisms this should be very much depends on the particular entity we're looking at. In the case of a child, of course, we wouldn't want to empower a child, him or herself, to see to it that the duty gets discharged because there are obvious reasons for this, so perhaps some third party. And what particular forms of empowerment, what particular mechanisms we should put in place very much also depends on the context at hand. Depending on the particular type of legal system, the particular social background, and so on and so forth, different mechanisms might be appropriate. Similarly, when we say, for instance, women, from a justificatory perspective, women have rights not to be battered by their husbands. That's another example that I give in the paper. what this would mean, again, from a justification perspective, is that mechanisms of social empowerment ought morally to be brought into place to see to it that these women's interests in bodily integrity be safeguarded. Now, the duties are already there, so I'm already assuming that there are duties there, that husbands should not, hit their wives and whatnot. However, a justificatory right statement points to the reasons, moral reasons that there are for bringing about particular mechanisms of social empowerment that might range within sort of a certain domain, depending on the context, depending on the entity, whether it's a child, whether it's an adult, whether it's a non-human animal, and so on, the nature of the interests involved, and so on. And there could be enforcement, compensation ex post, punishment, and potentially even the power to waive a particular duty. Again, I think it depends on the context at hand. But what the justification moral right statement does is points to the reasons for bringing about certain forms of social empowerment. One type of right statements. And then there are status moral right statements. And this, I think, point to justified social status, that is, to justified forms of social empowerment that already exist. So we don't look at the reasons, which are typically grounded in interest plus some contextual considerations, but we look at the statuses that are already there, that is, the forms of social empowerment. Again, the nature of the empowerment here will vary, same as before. And then if we look at right statements from a status perspective, what they mean is something like, women have rights against being battered by their husbands. They point to the particular forms of social empowerment that are already there and we consider to be justified, and that give women the justified standing to do a variety of things to see to it that their husbands don't do this. Promisees have rights. I'm taking promises to be a social practice, and it's a social, the practice of promises, promising, is a practice that gives promisors and promisees a particular standing, and so promisees have a particular standing vis-a-vis the promisor, so they have the social standing to either demand the performance of the promise or waive the promisor's duty. Parties to a contract have rights, again, similar story there. So, what to take away from this conceptual connection between moral rights and social empowerment? So what I want to suggest is that on the one hand, if this sounds plausible, we have a greatest common denominator of moral rights talk, and that is a reference to social empowerment. So it seems that when we talk about rights, somewhere, the reference to social empowerment of some kind being appropriate seems to be there. But at the same time, the connection between the idea of a claim right and social empowerment is to be located in two different places. If I'm right that sometimes these statements are of a justification kind and sometimes these statements are of a status kind. So the same statement might be given two interpretations in relation to social empowerment. So on some occasions, we're looking at the justification for empowerment, and on other occasions, what we have in mind is the actual empowerment itself, the existing social status. So there are different objects to which rights talk refers, and these are the objects that I've just mentioned. Again, a little bit of a sketch. So it seems to me that justification right statements deal with the relationship between, on the one hand, particularly justificatory reasons, typically interest, and that they go from there to the need to bring about particular forms of social empowerment. That's the area of conceptual space in a way that they occupy, while status right statements cut off the justification, but focus on the relationship between claim and duty. So the existing forms of justified social empowerment that one has in relation to someone else's duty. In sum, I want to suggest that there is something that unifies moral claim rights talk, that is the reference to the moral appropriateness of social empowerment. That's something that I think might be regarded as the greatest common denominator of moral claim rights talk. But the objects that rights talk picks out are of different kinds. Justifications for empowerment on the one hand, and I think those types of justifications tend to be interest-based, as well as various forms of empowerment. And here we have sort of a disjunction of possible types of empowerment. So the standing to demand ex ante, that someone performs a particular duty, standing to waive, to seek benefits ex post, to potentially have third parties make demands on one's behalf, etc., etc. what particular forms of empowerment we're looking at will, as I said, depend not only on the interest in question, the entity we're focusing on, but also on contextual considerations. And if this is correct as sort of attempt to organize our ordinary language of claim rights, then it should be no surprise that there's no definition of claim rights can do these two things. One, pick out a unique, distinctive deontic status, and fit all paradigmatic examples of claim rights in ordinary language, because those examples cover a variety of different things, both justifications and deontic statuses. And so there's going to be, if we go for a distinctive status, then there's going to be some instances of claim rights talk that we might regard as quite plausible, at least intuitively, that are going to be left out. And so, one Desideratum is not going to be satisfied. If, on the other hand, we try to be sufficiently ecumenical, so if I were to say something, claim rights, you might say, oh, look, Laura is putting forward some alternative theory of claim rights herself. That is, claim rights have something to do with social empowerment. Well, that's just very, 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 very broad. And it seems that we're not really looking at a unique, distinctive deontic status, but, a family of such statuses, and not only those, also the justifications for them, which is a little bit too much. Okay, so what should we do? And on this note, how long do I have?
5 minutes.
Okay, I think I'm good then. Should we do away with claim rights in moral philosophy? That sounds like a sort of like somewhat nuclear option. Okay, so what to do? If there's no definition of moral claim rights that can do all we want it to do, for the purposes of moral theorizing again, how should we proceed? There's probably more than 2 possible answers to these questions, but here I'm just going to state 2 of them. So, solution 1, which is the sort of modest, moderate option. Ask less of a definition, that is, be less demand, just drop the unique special deontic status, and just state clearly what you mean by a claim right, knowing that some paradigmatic rights, claim right statements are going to be left out because of the reasons that I mentioned. So just be clear, be a good analytic philosopher, define your terminology. So that's solution number 1. Solution number 2 is drop the notion of a claim right from moral theorizing, at least when you want to designate some fundamental deontic status, and speak directly about the underlying phenomena. Now, defending solution 1 I think is somewhat easy. I want to try to defend solution 2 just because why not? No, I have some reasons, it's not just another one. Okay, so first of all, it seems to me that holding on to the language of claim rights is likely to lead to confusion given how charged or evocative the language is. And this is something that I think I've come to, I should say, I used to make a rather big deal of something being a claim right in some other work that I've done. So, it's not exactly that I have been free of, coming from a sort of slightly Kantian background, I always, had very firm views about what claim rights were until it all fell apart, basically. And so, but more recently, I started to disaggregate and then work on claim rights, but at the very start of the papers I was presenting, say, and by a claim right, I mean the following, and being very clear. So I had a couple of papers where I was using the demand theory. So I think you have a claim right, you have a standing to demand the performance of a duty. But that's what I mean. And I have to say that despite this being sort of said loud and clear at the beginning, I don't want to say half the questions I got, but a good number of the questions I got were just premised on some other notion of a claim right. And I understand that, you might say, okay, well, too bad for them. You just remind the person who asked the question of what you stipulated at the beginning of your talk. But then I also wondered, well, why did I not just say, here I'm interested in the standing to demand the performance of someone else's duty without attaching the label claim right to it? Because if I had done just that, then the confusion would have disappeared. And so I wonder, why keep the notion and then say, by which I mean something more specific? Why not just dropping the notion and referring to that specific thing? Partly because there seems to be no genuine positive reason to hold on to that language, given that it turns out that language can't really do what we want it to do in the first place. So why holding on to the language? And I think that some of the resistance to the suggestion, look, we should drop it, is that that language is not just quite ubiquitous in moral philosophy, at least within certain circles. I guess not if you're a sort of utilitarian or super consequentialist, but also in legal circles. And this paper says nothing about claim rights in legal discourse generally. So, and in fact, I have various hypotheses of how some of the problems in moral philosophy come from a sort of unsophisticated import of some legal language into the moral domain. But also in political discourse, and the language of rights and claim rights seems to be quite powerful in that context. And so, do I want political actors to stop making demands on their governments on behalf of vulnerable people using the language of rights? That would seem to be, which they, typically equates what we pre-theoretically think of as claim rights. That, I think, would be not a conclusion that I would be happy with, because I think that language has worked well. But I don't think I'm committed to this conclusion in the present paper. And part of the reason is that precisely, I think, the heterogeneity that the notion of a claim right or a right in ordinary language is characterized by can be an asset rather than a liability in the context of political advocacy for a very simple reason. And here I'm thinking mostly about justification right statement rather than the status right statements. The status just point to justified matters of social fact. But when we think about justification right statements as a government, you need to see to it that certain things get, that certain mechanisms for empowerment get put in place. What we want is to use these statements to, say, begin a conversation as to how we can empower certain agents to see to it that their interests are being protected. And then, there's going to be very much applied discussions about what the best mechanisms are going to be. So here, to some extent, the fact that by using the notion of a claim right, we're not already straitjacketing ourselves in a particular way, but we're making a claim, look, something needs to be done, and then, once that is being accepted, we can look at the nitty-gritty of what specifically needs to be done there, I think is a plus rather than a minus, and potentially also why the notion, although this is a very speculative sociological claim that I'm in no position to back, potentially why that notion might have been so useful. I mean, the slipperiness, to some extent, might be an asset in that kind of political contestation context. Okay, so on this note,